Disney has been countersued by the district in state court. So now the real case begins. Yes, we finally have the real state court case, the actual underlying issue that needs to be resolved before Disney's federal case can go through. As of May 1st, we have a brand new lawsuit in this fight of the district and the state of Florida, really, against Walt Disney World and the Walt Disney World parks. Of course, I'm Andrew Esquire. This is Legal Mindset. We teach you to be your own judge. And I have been like a dog on the bone on this issue, and there has been more and more and more coming out. And now we finally have a state countersuit under state law, under municipal law, property law, as it should be, evaluating the statute, evaluating the government powers. And this is beyond all things a preliminary issue that needs to be resolved before the federal case can proceed. Let me say that one more time for those with a little pixie dust in the ear. If this issue is not resolved, the federal case cannot go forward. These development agreements need to be proven that they were valid under state law. If they're invalid, Disney has no case. They have zero standing in their federal case, absolutely none, nil, zilch, and their case will be absolutely bunk, tossed out of court. In fact, you can say that these agreements may have been manufactured to give Disney standing to bring this argument, because without this argument, well, they've got nothing. I mean, unless they want to confess to $1 billion in securities fraud. And if you want to learn more about securities fraud, what am I talking about? Bonds. Go check out my videos on bonds, on security fraud, the catch-22 of Disney. Got many videos on that, specifically my catch-22 video. But we're going to get right into it today with the actual countersuit. So this is filed just today on the 1st with Judge Denise Beamer. She often handles a lot of the complex litigation in Central Florida. It's in the 9th District, my former district where I used to practice when I was in Orlando. Of course, I specialized in local government and special district law. This is what I did. I actually represented almost all of the special districts surrounding Disney. For example, Bonnet Creek, Celebration, Reunion, Mystic Dunes, a lot of those were represented by moi. So I know about this, and I know about this area of law, which is why I love to cover it. So this was filed by Charles Lawson of the Lawson Law Group, a former Supreme Court judge, actually, who now has his own firm. He is representing the Central Florida Tourism Oversight District. Mind you, this is the successor to Reedy Creek. Reedy Creek is gone. I no longer call it Reedy Creek. I call it the CFTOD. I know it's long. I know it's not catchy, but I'll just refer to it as the district because it is now the district. And when I say the district, I mean the special district successor to Reedy Creek. But it's important that it is not Reedy Creek because it is not controlled by Disney. It is in fact controlled by state representatives. So this has been properly filed in the court, confirmed here. They paid all their fees. You can see they paid their $400 to file, and we've got the standing case management, 3 pages, the complaint, and the civil cover sheet. We're going to get right into the complaint. This is, of course, in the 9th District of Florida in Orange County, the Circuit Civil Division, the Central Florida Oversight District versus Walt Disney Park and Resort. It's so fresh off the presses. Look, we've got a filing number, but we don't have a case number yet. So that is something we don't have because this is so freshly filed. But as always, your boy Legal Mindset covering it immediately off the press. So here you go. Here's the complaint for declaratory and injunctive relief. So the plaintiff, Central Florida Tourism Oversight District, the district, alleges in support of its complaint for declaratory and injunctive relief as follows. So we're going to get into some basics. And by the way, this is a 188-page complaint. However, about 30 pages of it are legal argument. The rest is backup. So you're talking the Reedy Creek statute. We're talking about a meets and bounds, like a lengthy legal description of property. So this is about a 30-page complaint. Now, I know there's some others out there like the Legal Schmeagles of the world and their lackeys who are always impressed by the length of a complaint. The length of a complaint doesn't say anything on its own. It's the strength of the legal arguments within. So I'm going to be analyzing this for the strength of the legal arguments. So they start out here in the introduction. For 55 years, Walt Disney Parks and Resorts, its predecessors and affiliates, ran their private government on 25,000 acres in Central Florida. Within its fiefdom, Disney wrote the laws that governed itself and chose whether and how to enforce those laws and set its own tax rate. No other Florida business, large or small, enjoyed these benefits. That is absolutely true. The benefit that Disney had in Florida was unprecedented. No other business ever has had it. And in fact, when other businesses like Universal asked for it, they were denied. So Universal does not have a special district. They don't. They just deal directly with the county. That's how every other business, including theme parks, Legoland, SeaWorld, none of them have these benefits. Just Disney. Why? Because they promised to build a city that they ultimately never built after Walt passed away. There is no question that much good came from the special status the Florida legislature granted Disney. That is true. They did grow rapidly because of that special status back in the day. But over time, Disney uses influence to obtain what may have seemed like permanent exemptions from the democratic checks and balances that apply to all other Florida businesses. And to that effect, by the way, all other Florida governments. For example, like other businesses in Florida, Disney is subject to building and fire codes that are supposed to protect the lives and safety of its employees. But unlike other businesses, Disney did not have to worry about these safety rules would be enforced against it. Yes, that is because Disney-controlled district board would never adopt any mechanism for enforcement of those codes. So they never were going to enforce building codes, fire codes against Disney. Disney could do whatever it wanted because it set its own rules. This is what happens when you self-regulate. Earlier this year, however, the Florida legislature took steps to restore the people's sovereignty and establish an independent board to govern the district, a truly independent board, as it should be. A government should always have an independent board that stands separate from corporate interests. That's quintessential to the definition of government. And I will tell you, as somebody who practiced in this area, and we saw this issue with the villages, when it is simply a corporation using a government as an alter ego, that is something that under the federal tax code, as well as under Florida law, is not an actual government. It's not a real government if it's just an alter ego of a single corporation. That's not what a government is supposed to be. In an effort to stymie Florida's elected representatives, Disney covertly cobbled together a series of 11th-hour deals with its soon-to-be-replaced puppet government. Disney hoped to tie the hands of the newly independent board and preserve Disney's special status as its own government for at least the next 30 years. That's 30 years because of our Marketable Title Act. After 30 years, those would fall off. I know a lot of people made much to do about the King Charles clause, but that actually doesn't matter. It's something that's legally irrelevant. It was cute, but really an irrelevant thing. So really, after 30 years, anybody who knows Florida real estate knows it would fall off. That's why I said, look, anybody who's getting bamboozled by this King Charles stuff doesn't know how marketable title works in Florida. After 30 years, that clause is going to fall off, and the covenants are going to be unenforceable unless they're re-upped, which obviously the new board would not do. Those agreements reek of a backroom deal drafted by Disney with the acquiescence of a lawyer who represented both Disney and the district. By the way, that would be John McGowan, who was special counsel for the district and also Disney's chief counsel. Funny how that worked. Set a hearing without proper notice and hustled through a compliant Disney-controlled board that Disney knew would not dwell long on the issue. But perhaps out of haste and arrogance, Disney's deal violated basic principles of Florida constitutional, statutory, and common law. As a result, they are null and void, not even worth the paper they are written on. This is the key here, guys, and what I've been harping on. So the last week, excuse me, I got a cough here, and it is 1 a.m. in Seoul, South Korea, but I'm running through this with you guys because this needs to get out because this is urgent. I have been, over the last week, pumping out reason after reason after reason after reason after reason why Disney will lose even the federal case. This is just bringing those together, saying, look, they're going to present constitutional, statutory, and common law reasons why the agreements, those development agreements, those 11th hour agreements that were passed are invalid. Mind you, any sort of statutory agreement has to comply with, yes, the statutory law, the Constitution, because it can't violate the Florida Constitution, and the common law, the law that's been passed in the courts as related to those sort of agreements. And because it has to comply with all of those things, and it clearly fails for the reasons that I've mentioned, but we're going to hear again in the complaint, that's why it would be void ab initio. So that's that word void from the start. The new board has already taken action to bring accountability, transparency, and normalize even-handed administration to the government Disney used to run. It has adopted rules governing board conduct, hired an outside financial advisor to ensure financial transparency, and retained new independent outside general counsel who are experienced in local government law, as they should be. You need a specialist. This is what I've been harping on. This is why I was paid the big bucks in Central Florida, because this is a very specific area of law with specific rules. You can't just hire any local yokel to do this. In fact, you can't even hire a lot of big law firms because they don't do Florida local government law. They don't cover special districts. It is very specific. You need to know bond finance. You need to know public law, right? As it relates to the powers of special districts, statutory law, how those are actually applied. This is why you cannot just hire anybody. You need specialists. Unlike Disney's former general counsel, are not also Disney's lawyers. So yes, you need to have independent counsel. And it is extraordinarily unethical to represent a company and also the government that is supposedly independent from that company. That is wildly unethical. The new board has authorized the drafting of fire and building code enforcement provisions, one of the most basic safety protocols that prior Disney Control Board never bothered to require. Basic building and fire. Every building has to comply with this. But Disney wants an exemption from basic safety. Remember that dragon that burned down? Yeah, let's continue here. Also, the board has hired an urban planner to make recommendations to the Florida legislature about strategies to make the district more prosperous for those who live and work in and near it. I think that's very good. I think that there should be some thought to how the district is developed. When the new board took office, it expressed to Disney its desire to work together to achieve a win-win scenario that would protect Disney's economic investment in the district, but at the same time, usher in a new era of accountability, transparency, and cooperation with the district's other occupants and neighbors. Disney would have none of that. Instead, despite the obvious deficiencies in the one-sided deals Disney drafted for its former board members to rubber stamp, Disney continues to insist they were valid and enforceable against the district. The district, therefore, seeks a judicial declaration regarding their invalidity. In fact, that's the whole thing here. Disney insists in their federal complaint that these declarations, that this agreement is valid. It's not. And if it's not, they have no federal case. Once again, this is everything. This is why this state law case is the real case. That case in federal court, that's a joke. This is the case that Disney actually has to fight. This is the one to pay attention to. And I will say this as well. Having been someone who was representing Disney's neighbors, right, whether it was Celebration or Bonnet Creek or wherever else, this is absolutely true. All Disney deals were one-sided. If it wasn't completely in Disney's favor, they didn't want you to come to the table, right? They wanted to do what Disney wanted to do. If you weren't there to listen to Disney and bend the knee to the rat, they weren't having any of it. So obviously this is parties and jurisdiction. Obviously this is a special district, right? The CFTOD is a special district established pursuant to the 67. So they're a legacy of that, right? But they were reauthorized recently. So the district exercises local government authority as authorized by the legislature over approximately 25,000 acres in Orange and Osceola County. So it's multiple counties. Prior to the 27th of 2023, the district was known as Reedy Creek. So this is clear that this is the successor to Reedy Creek. So the CFTOD is the successor to Reedy Creek, but Reedy Creek no longer exists. For ease of reference, this complaint generally uses the term RCID when discussing actions taken by the district prior to February 27th. That's very useful. By the way, that's the common slang. I used RCID as well in all my documents referencing Reedy Creek whenever I did deals with Reedy Creek. So this is the common slang for these guys. This was the date of the governance of the district was statutorily transferred to the new board, including the adoption and execution of the development agreement and the declaration of restrictive covenants at the heart of this declaratory relief. The defendant is a Florida corporation with its principal place of business in Orange County. Disney owns and operates Walt Disney World within the district boundaries. These reasons, guys, because the district and Disney are in Central Florida, makes this the most appropriate venue. Federal court in the Northern District, not appropriate at all whatsoever for this case. This is a quintessential Florida law case. It's about real property. It's about Florida statutes. It's not about the First Amendment. The court has jurisdiction over Disney because of the Florida corporation with its principal place of business. All right, obviously, this is subject matter jurisdiction because it's over $50K. And venue is proper because Disney has an office for transaction of its customary business in Orange County. The action is accrued in Orange County, and the property subject to the development agreement is located in Orange County and a bit of Osceola County. I would add that in there. But either way, that's the Ninth Circuit, so very appropriate. Factual allegations, Disney's control over Reedy Creek. So in 1967, the legislature created Reedy Creek. Disney World owned the majority of land within the boundaries of RCID, and the Florida legislature hoped that creating RCID would assist the Disney company in its plans to develop this area of Central Florida. That was their plan, to use RCID to develop it into a city initially. The plans not only included a theme park along the lines of Disneyland in California, but the construction of a planned community that Walt Disney called the experimental prototype community of tomorrow. Shout out to my good boy, Valiant Renegade, WW Pro, Mexican Iron Man, those boys. We've been talking about this forever. This was all hinged on Epcot, the experiment prototype community of tomorrow, being an actual community, an actual planned community. Walt's true vision was a planned community. He was big into that. The theme park opened in 1971 and was a financial success. However, Disney's plan, especially after he died, never materialized, although Disney co-opted the name for its Epcot theme park. Epcot is a shadow of what Walt wanted it to be. That was supposed to be an actual community, not something where you hire minimum wage workers from around the world, repping different countries. No, that was not what it was supposed to be at all whatsoever. It was supposed to be an actual community. Closer to, if anything, closer to Celebration than anything else. Although Celebration is a far cry from the dream of Walt, who wanted an actual city where work was done with offices and all that stuff under that oversight. On its face, RCID appeared similar to other special districts periodically established by the Florida legislature. Like other special districts, RCID was authorized to exercise many of the traditional powers of local government, such as regulation of zoning and development, capital improvement, building code enforcement, fire and safety. They also gave RCID the power to levy ad valorem taxes. Very normal, all normal so far. RCID was governed by a 5-member board of supervisors, whose only qualification was that they own at least 1 acre of land within RCID. Election required a majority vote of the electors, who had to vote at least 1 acre of land and cast 1 vote for every acre owned. But behind this democratic facade, Disney's rule was absolute. No individual owned 1 or more acres of property within RCID, which meant no one could qualify to sit on RCID's board of supervisors. Indeed, Disney sought to limit residents in the district altogether, turning Epcot into a theme park instead of a residential community, and de-annexing the town of Celebration so the town's inhabitants cannot dilute Disney's control. That was a big part of Celebration, was getting it out, getting it under its own government. Celebration has a CDD, a Community Development District, which is the power that controls Celebration. In order to constitute the board, Disney would identify a suitable individual, deed him a parcel of land within RCID on a temporary basis, then nominate that individual for election to the board. Because Disney owned almost all the land within RCID, Disney's chosen candidate won election to the board every time. Of course, Disney's gift to its handpicked board members came with strings attached. On information and belief, Disney retained the ability to force the board member to return the deeded land, and thus to vacate the seat on the Board of Governors at any time. And when a board member left his seat voluntarily, they were similarly obligated to transfer the deeded land back to Disney. Under this governance structure, Disney controlled who got elected to the board and could remove any member at any time for any reason. That appears to be true. And from everything I heard, that was true. Through its control over RCID, Disney operated its own government within the RCID, establishing its own zoning and development laws and regulations, deciding how and when to enforce the building and fire safety codes against itself, and even controlling law enforcement's access to its property. It was, in short, both governed and the government. No other private business in the state of Florida enjoyed the advantages that Disney had through its control of RCID. Very correct. Universal, no benefit. SeaWorld, no benefit. Just RCID and Disney. Florida legislature brings public accountability to the district and brings Disney to parity with other Florida businesses. Initially, the deal struck between Florida's elected representatives and Disney was mutually beneficial. Yes, for many years it was. Disney clearly benefited from it. So did Orange and Osceola County, whose tax bases in the 1960s were lackluster. And this is true. This is the part where Disney is absolutely right, that Disney did grow Orange and Osceola County. That's true. Two things can be true. Disney helped Central Florida, but Disney is also wrong in this lawsuit under Florida law, right? You don't have to, it doesn't have to be an extreme. I love how the Disney simps make it like Disney did everything from Florida. You are not respecting Disney's authority. Okay, great. They did good things in the past, but that doesn't give them the right to usurp authority, usurp the state of Florida. This was always a key mistake here. But over time, Disney exercised its outclassed political influence to extract additional exceptions and exemptions from the rules that applied to all of the Florida business. What began as an interesting and innovative experiment in privatization devolved into a depressing example of crony capitalism. Disney used its special status to arrogate to itself an unprecedented authority to decide what rules they would and would enforce against Disney, setting Disney apart from every other business in the state as a law unto itself. Disney was the law. They are so terrified to lose this authority to govern themselves. You will now see things that are happening inside of Disney, and they will actually be transparent. You will see when there's crimes inside of Disney, when people die inside of Disney, right? And they try to keep that hush hush. Nuh-uh, not anymore. Florida public records law is a thing. The reason why Florida Man exists is because our transparency laws are so strong. Yeah, you're going to get a lot more stories from inside Disney. That's not going to be hush hush anymore. Florida's elected representatives decided it was time to reform the RCID and put Disney on the same footing as every other Florida business. On April 22nd, 2022, Senate Bill 4C became effective and thereby required the dissolution of RCID. Disney, like all other successful tourism venues, would be subject, at least in part, to regulation by Orange and Osceola County. Very normal. Once again, all the other tourist attractions, all them, Universal, SeaWorld, all that, right? The Holy Land Experience, RIP, that went out of business a while ago, subject to Orange and Osceola County regulation. The Florida legislature ultimately decided to reform rather than abolish RCID. So they decided to create a new entity, which is, by the way, what I said the entire time, that the whole disband and then, dealing with the bonds and having to call those bonds, they weren't going to do that. They were going to ultimately create a new district and transfer those over, which is what happened here. So it reformed. So H9B amended the special act, which amongst other things reformed their governance structure. So now they were appointed by the governor and confirmed by the Senate. So this is very common for multi-county structures. This is not something uncommon for multi-county structures that the governor appoints the board. In fact, I have formed several districts where we had to go and get a board appointed by the governor. Now, in the case of my districts that I went to do, this very thing, we told the governor who we wanted appointed, and he just appointed them because he trusted us to do it. And the people we were offering up were skilled and talented people who were actually knowledgeable about those districts. So let me be very clear. It is something that requires some, elbow grease to get done, but this is something that is not uncommon. I have done this. So this is something, once again, when people try to say, oh, well, this governor picks the board members. No. This is standard. And in fact, when you go to a county, right, and you're setting up a special district, initially the county appoints the board. So if I was going to form a district in Orange County, I would have to come to the Orange County board and say, hey, Here's my 5 board members for my special district. Let's call it the Andrews Super Fun Time Nintendo Excellence District. That district, I can name, Larry, Curly, Mo, Jim, and Bob, right, to the district. And they would, as long as they trusted, me as a lawyer and my firm, they would say, you know what, this is good. These people look educated. They have a background. This is good. We're going to appoint these people to the board, right? Typically, they're not going to question that. But this is not something so odd. But anyways, Disney gets RCID to rubber stamp illegal agreements to perpetuate its reign over the district. In response to various legislative reforms, Disney engaged in a concerted effort to perpetrate its stranglehold over the district, using its control over RCID and the 2 municipalities that exist within the boundaries of the district, the city of Lake Buena Vista and the city of Bay Lake. In the same way that RCID was a company district, Lake Buena Vista and Bay Lake are company towns. Disney selects who can live in the mobile home community. Shout out to WW Pro, Valiant Renegade, those famous double wides on Disney property. Located on Disney's property in each municipality, and thereby controls who can stand for election to the representative city councils. Disney's 11th hour rush to insulate itself from the authority of the new board, however, produced agreements that are riddled with procedural and substantive flaws. Earlier in November 2018, the RCID, Lake Buena Vista, and Bay Lake held first readings on proposed amendments to their joint comprehensive plan. This is a big thing. When people update their comprehensive plan, this is usually a multi-year effort, and there are specific statutes you need to follow. This is very important in Florida, and this is why lawyers who do not do municipal law, who do not do local government law, they can fuck these things up, because there's very specific notice you have to follow, very specific procedures. You can't just do them willy-nilly. You got to do it according to the statute, by the book, exactly how they say it. Key to all of this. In May 2022, after the passage of 4C, RCID, Lake Buena Vista, and Bay Lake purported to hold the second readings on their proposed amendments. But the amendments considered at the second hearings were significantly different, from the amendments considered during the first readings in 2018. So this is a major issue. So if you have significant differences, you're gonna need to re-up that. So among other things, they purported to change the permitted uses within RCID's boundary to significantly increase the permitted densities and intensities of development within RCID, and to call for the construction of significant public facilities projects financed by the issuance of new bonds. So all of this is a significant major change, which does trigger statutes, big changes. Despite these significant differences, the 3 Disney-controlled governments purported to adopt these new amendments in May 2022. Then, on February 8th, 2 days after filing of HB 9 signaled that Disney's absolute rule would soon come to an end, Disney quietly contrived with its puppet board to extend the government powers by contract. Disney approved and adopted a 30-year Disney designated development agreement and declaration of relative restrictive covenants between itself and Disney. I would actually correct this complaint. Now, I will say, yes, a development agreement is a type of contract, but a statutory contract, let me be very clear, a statutory contract must follow the statutes. It is not absolute freedom of contract. So anybody talking about freedom of contract, that doesn't apply to a statutory agreement. You have to paint by numbers with statutory agreements. They can only do what they say specifically in the statute. You cannot color outside those numbers. So I want to defeat a little bit of the talk about those in terms of a pure contract analysis, but it's not wrong to call them contracts. However, with the restrictive covenants, the Declaration of Restrictive Covenants are not pure contracts either. They're very, very specific. They have to have a certain type of notice. Once again, everybody has to be on notice before restrictive covenants are recorded. Everybody. I mean, everybody. And they got to consent. They got to have the intent to record those, and they have to touch and concern the land. That means they have to be specifically concerning the use of the land. There's a lot of provisions that were in this that were related to intellectual property and other things, which have nothing to do with the land and would therefore be invalid. So I just want to say the basic, I would say the vanilla latte analysis, like the very basic analysis here of this as a contract, these as contracts, it's not good enough. You need to know Florida statutory law and you need to know Florida real property law, which fortunately is my area of expertise. In their haste to seek to insulate Disney from meaningful government regulation, and Disney and RCID failed to comply with the basic statutory notice requirements, and the RCID lacked authority to enter into any development agreement because it had not enacted an ordinance governing the process for doing so as is required by Florida law. This is fantastic. If there is a prerequisite, and it is a hard prerequisite, you need to do it. It is a statutory must. It's not a maybe, it's a must. So if they're not following the statutes to the letter, they're in trouble. Copies of the development agreement and restrictive covenants attached as complaints, respectively. And these are very long documents. We're not going to go over them again. I've gone over them previously. I've attacked those previously. So we're focusing on the legal analysis portion, but they are attached as exhibits. I did see those. I can scroll down and show you where those are, but those are the exhibits. Neither the development agreement nor the restrictive covenants were previously presented to RCID planning staff for their input and consideration. Both the development agreement and the restrictive covenants purport to assign to Disney much of the district's governmental authority. For example, the development agreement mandates, on a prospective basis, development within the district boundaries at the maximum levels, including the maximum densities and intensities that are described in the amendment to the comp plan. I know this sounds complicated, guys, and what this has to do with is, look, when you are developing land that's undeveloped, or rather maybe it is already developed, maybe it already has a property on it, and you want to build more, let's say you have a hotel and you want to add more rooms, yeah, you have to up the maximum density and intensity. Otherwise, you may be capped out and not be able to build more on that land. Moreover, the development agreement gives all the development rights within the district's boundaries to Disney, which pursuant to the development agreement now owns and controls such development rights. This is actually a very controversial issue under Florida law, and most people don't recognize this. But what this is there's certain rights to develop, for example, to build property, to build hotels, to bulldoze down trees, right? When you bulldoze down an acre of wetlands in Florida, for example, you need to have conservation property to offset that. And the entity which maintains the conservation property, guess what that was? Yes, RCID. So RCID is the one that maintains the wetlands, the conservation property that allows Disney to build. And those rights were going to be passed to the Central Florida Tourism Oversight District. In fact, I will actually say they were passed because these development agreements, once again, were void. So those were still passed. Those development rights were still passed to the Central Florida Tourism Oversight District. And by the way, that is the proper entity because they are maintaining the wetlands and all the conservation property. So they should maintain those development rights. That's only proper. They're taking on the burden, therefore they get the benefit. And they haven't denied so far, because Disney hasn't made a request, the use of those development rights. So Disney really, even for the federal suit purposes, doesn't really have damages. It's not like the district has told Disney, you can't do this. They haven't asked. Disney's never asked. They just went and whined straight to federal court. So, and I know this can get a little wonky, a little nerdy with the development stuff, but just understand the district is paying on an ongoing basis, year to year, hundreds of thousands of dollars, maybe even millions. I haven't checked the budget, but it is a lot of money to maintain that land, to maintain that mitigation, those wetlands, to maintain that land within Reedy Creek. So Disney wants the benefit of that maintenance without the burden of having to pay for it. I mean, yes, they pay for it indirectly through their taxes, but they want all those benefits to come to them and only them. So thus, any other property owner. So remember, there are other property owners within RCID. In fact, there's many other property owners within RCID other than Disney. Disney is the majority, but they're not the only one. So mind you, here's the issue. Any other property owner who proposes development within the district would require the use of these development rights, and they must obtain prior written approval from Disney. It is left to Disney's discretion whether or not to assign development rights to other property owners. That is not fair. The entity that should do that is the government. The government should be the independent mediator that says, you get these rights and you get these rights and you get these rights. That's what the government does. That's what your local government does. It assigns out these development rights. This is what governments do on a regular basis. This is what the CFTOD should be doing. This is what nearby districts, whether it's Celebration, Bonnet Creek, wherever else, that's what they do on a regular basis. Over in Bonnet Creek, they actually assign those development rights between the different hotels. There's different hotels there, the Waldorf, the Wyndham, Hyatt, JW, right? The JW Marriott. All those are over there, and they assign the development rights based on how much they're contributing, how much acreage, how many keys in the hotel, yada, yada. They assign those out. They parcel those things out. So that is how other places do it. And you need a fair entity to do that over there in Bonnet Creek. That's the Bonnet Creek district. That's what that district does. And it's all commercial, right? So you flip over to Disney. Well, why can't Disney do that? Why can't Disney do what every other district does? Well, because Disney has to be better than everybody else, right? Disney has to be above everybody else. They have to play by different rules. That's not the rules that special districts play by in Florida. Once again, lawyers who know about this know this. This is common sense to us. But I know to Disney and it's, where it's ruled within this fiefdom, this is all new news. Under the development agreement, Disney is now required to under the development agreement, the district is now required to issue new bonds financed by ad valorem taxes collected from all the district's taxpayers in order to fund infrastructure. That's not fair. So they want the district to tax everybody to pay for just Disney. Do you get where we're going with this? They want to force the district to do what Disney says, to force a government to do what Disney says. Yeah, that's not a government. That's a puppet. No, just plain no, that's not how it works. You don't force, a private entity does not force a government to act. Similar, under the restrictive covenants, Disney restricts the district to using its own property solely for those uses existing on February 8, 2023. Once again, and this is the restrictive covenants allow Disney to censor the district's speech on its own property, and the restrictive covenants prohibit the district from altering its own property without Disney's review and consent. I see where they're going with the speech thing, and once again, I call balls and strikes here, so I'll call them balls and strikes against these drafters. Framing a speech, it's a little interesting, right? I wouldn't frame it that way. I would put it more of the second half here. It's preventing it from using its own property. A private entity under Florida law shall not and cannot be allowed to control a government entity. Restrictive covenants of a private community do not bind governments. This is settled Florida law. This is not up for debate. This is not up for discussion. This is settled Florida property law. Let me say this one more time. Let me even go like bigger mode here. Okay, I'm over here. Restrictive covenants passed by a private community in Florida cannot bind a government. Period. End of story. No debate. Imagine the precedent if your HOA could control what a government did within the boundaries of those HOAs, right? They could say, hey, every police car that drives this neighborhood has to have a rainbow flag on it. It's got to have the Twitter logo on it. It's got to have a Care Bear on the top, whatever. Imagine if that happened. It would be a horrible, horrible precedent for the state of Florida to allow private communities to control the government when they're operating within their boundaries of that HOA. It's not permissible, and it's entirely counter to Florida law as well as real property law. So just throwing that out there, the government is not bound by your private covenants, period. So going into 25 here to D, the development agreement and restrictive covenants are riddled with procedural and substantive defects. They not only violate the plain and unambiguous statutory language governing our CD's adoption, but also the well-settled principles of Florida constitutional common law. Yes, I would agree there. Each of these defects separately renders the development agreement and restrictive covenants null and void. After the presentation from its outside counsel, the district's board of supervisors adopted legislative findings regarding the various defects in the development agreement and restrictive covenants. So they consulted with counsel and they adopted the legislative findings saying, hey, these are not legit. And they found they are void ab initio. It's as if they never existed. And by the way, Disney filed suit as soon as they voided these agreements. This is the thing. And by the way, Disney's filing of that makes it very clear that this is the only thing giving Disney standing. So this is once again why this is the real case. This shows, the timing here shows that this is the real case. Disney's whole federal case is Fugazi. They were always worried about the development agreement and the restrictive covenants. If we're not talking about the development agreement and restrictive covenants, we're really not talking about the real case here. We're really not talking about the real issue. They're off base. First Amendment, it doesn't even, you can't even bring that argument if the development agreements are void. Period. That's why this is first. The need for declaratory relief. Disney continues to assert these agreements are valid and enforceable, including filing a lawsuit, that's the federal lawsuit, claiming purportedly to arise under federal law that seeks to revive and assert rights in the development and restrictive covenants. Based on the facts, there are bona fide, actual, present, and practical need for the declaration of these agreements and restrictive covenants as void, unenforceable, and valid. So this is all very, very much true. An immunity, power, privilege, or right of the district, namely the district's ability to conduct its own affairs and govern freely from the illegal obligations and restraints imposed upon it, stands to be affected by the actions of Disney. Yeah, the district will pretty much just be a Disney puppet if these are in place. Disney has engaged in acts demonstrating an actual, present, adverse, and antagonistic interest. Very true. So a lot of people say, this is DeSantis doing this. This is DeSantis. No. This was done. And then Disney decided to file the lawsuit. Let me just say this myself, like as an attorney covering this. I thought I was done. If you look at my videos, I like assumed like, oh yeah, I'm done with this. This is like the end of this, this saga in the Disney saga. And then it's more and more and more. I didn't want to be up. Right now it is 2 a.m. in Seoul, South Korea. I live in Seoul, South Korea, for those who don't know. I don't want to be up right now. But I was like, look, this is going faster and faster and faster. I need to cover it right away and get this when it's right fresh off the press. So this is something that was happening in reaction to Disney and solely in reaction to Disney. So Disney's action has created insecurity and uncertainty with respect to Disney's rights, status, and other equitable and legal relations. The antagonistic and adverse legal interests of the parties warrants a declaratory judgment. Very much agree there. The relief is neither merely advisory nor the answer to questions propounded from curiosity. Indeed, the Florida Land Development Agreement Act, which governs the development agreement, that's Chapter 163 of the Florida Statutes, provides that any party to a development agreement can seek injunctive relief to challenge the compliance of the development agreement with any of the Act's requirements. So once again, this is a Florida statute, and therefore the proper place for judging Florida statutes is Florida courts. So count one. This is the first reason why it's invalid. And once again, this is what I've been covering on my channel. I just dropped a video on failure to provide proper notice before this dropped. So I had not seen this when my video dropped. But just this alone, just failure to provide notice, that is lethal to any possible levying of a development agreement. You have to have that specific notice. So obviously you incorporate the previous paragraphs. And so they were trying to enter into this under Chapter 163. Like you said, you need to have a very specific mandatory express notice. This is language from the statute. And if you guys saw my video on notice, you'll be familiar with this, but I'm going to read it again for posterity. So there's the express mandatory notice provision, which says, and I'll read the first part in a second, before entering into amending or revoking a development agreement, a local government shall conduct at least 2 public hearings. So that's not a maybe, not a sort of, sometimes, shall. 2A says, notice of intent to consider a development agreement shall be advertised approximately 7 days before each public hearing. Notice of intent, here's the key, here's the money shot in the italics. Notice of intent to consider a development agreement shall also be mailed to all property owners before the first public hearing. all property owners. Here is the issue. They didn't mail it to everybody. They didn't mail it to everybody. Disney is not the sole property owner. Whoa. In addition to land owned by the district itself, other property owners include private entities not affiliated with Disney and government entities. The development agreement affects those other property owners. Prior to entering into this, they held 2 public hearings. So one on the 25th and one on the 8th. So RCID published notice of intent in the Orlando Sentinel, and the notice were published on the 18th and 27th. However, such notices did not fully inform the public or other property owners of the purposes or contents of the development agreement, or how the property owners and taxpayers of the district were affected by the proposed agreement. It didn't talk about it at all. They did not post a copy of its agenda packages on its own website. That is actually a requirement. So under Florida law, you are required to post it to a website. That is new Florida law for special districts. Guess what? They don't know. Ed Milgram and those that were working on this, John McGowan, chief counsel for Disney, he doesn't know about these random special district requirements. I knew about them. This is something we actually had to change. When I was working with special districts, some of them had no website. And we said, guys, you got to have a website because it's now required. We post this beforehand. We've got to post the agenda. We've got to post the minutes. You've got to upload the board packages. By the way, shout out to the new board, the CFTOD. They now have a YouTube channel. So they're now streaming. You guys can check those out on their streaming channel. So they didn't do any of these things until the new board took over. Copies of the proposed development agreement and restricted governance were not posted on their website. Once again, these are required things. They're not optional. These are indeed required. Going to hit this water here as we go forward. So RCID did not mail its intent to consider a development agreement to all property owners. The failure to mail a notice of intent violated the mandatory notice. Once again, this is black and white. You either do it or you don't. RCID approved and adopted restrictive covenants as depending on the development agreement. So they're entitled to a declaration that the development agreement is void, unenforceable, because the restrictive covenants depend on the development agreement. They're void and enforceable. Also, by the way, restrictive covenants also require notice of all parties. So that actually, they could add a 3 to that. But regardless, the restrictive covenants were placed within the development agreement. They were tied to it. So without the development agreement, the restrictive covenants fail. Okay, count 2, ultra vires, which means beyond the powers. This is a very common principle of municipal law, local government law. Very familiar with that. In fact, right here, this law, the Local Government Development Act, was passed in the year I was born, 1986. The Florida legislature empowered local governments to enter bilateral development agreements by passing the Local Government Development Agreement Act. So this was to help local governments with development, speed along development in their communities, and enter into agreements between the government and a particular developer to kind of set out the course of development so the developer doesn't have to come back for repeated approvals. When you're building, let's say, a big project, you don't want to have to get every little this, that, and then approved. You want to have development approvals, just go ahead and build it, right? So that was the thought behind the Development Agreement Act. Absent the enactment of such ordinance, a local government is not authorized to enter into a development agreement. This is very, very important, guys. This is what I said. When I said there's no freedom to contract, this is what I mean. You need to strictly comply with the statute. You don't have freedom of contract. So remember, in the federal case, Disney talks about the contract clause and freedom to contract. And this is about our freedom to contract under the Constitution. I laughed at that. That does not exist under Florida law in 163. You color by numbers. You have what the statute gives you, not a drop less, not a drop more. And if you don't do exactly what the statute says, it's completely null and void, void ab initio. It's as if it never existed. So it says here, indeed, such statutorily mandated procedures and requirements are necessary to avoid precisely what happened here. A board of yes men and women Got to include those women, ladies. It's 2023. You got to include those women. A consequential deal with no established process or deliberation. The RCID failed to satisfy this condition precedent by entering into the development agreement. The RCID did not pass any law or adopt any regulations to establish procedures or requirements to consider or enter into a development agreement. So, once again, these are all conditions precedent. You failed to satisfy even one of them, whole thing fails. I know it seems strict, right? I know it seems crazy, but that's how statutory law works. That's why people get paid a lot of money to make sure that all the T's and I's are dotted and crossed on these local government issues. Because RCID did not pass a statutorily mandated enabling rules and procedures, the RCID lacked authority to enter the development agreement. The RCID's approval and adoption of the new development agreement was an ultra vires act. The RCID approved and adopted the restrictive covenants as depending on the development agreement. So the restrictive covenants depended on the passing of the development agreement once again. So it was beyond their powers to enter into that agreement because they had to follow the statute or they had no power to contract. This is why the contract clause stuff is bullshit in the federal case. So once again, seeking a declaration that the development agreement and restrictive covenants are invalid. Already on count 3, the district lacked authority and jurisdiction to enter into the development agreement. So under the terms of the development agreement, any local government laws and policies concerning development were in effect as of the effective date, February 8th, govern development under the development agreement for the duration of the development agreement. That sounds complicated, but what they're trying to say is all rules that applied on February 8th continue to apply. Because what did Disney want to lock in? They wanted to lock in their benefits. They want to lock in things that benefited them, like living with no fire in building code, right? They wanted to lock that in. They wanted to get away. I mean, seriously, they wanted to get away with having no building or fire codes. I'm not joking you. This is the standard. If you run a business out there, those who are in a business, maybe you're managing a business or you paid attention during the company briefings, you probably know there's like fire and building standards, like, I don't know, to make sure the building doesn't collapse or, people aren't trapped in a fire and like can't get out. Yeah, those are like basic things that every business in America has to follow, except for Disney. Is that reassuring? Does that make your vacation magical to know you could be consumed by fire in Disney? Yeah, that doesn't make it magical for me. Anyways, Bay Lake and Lake Buena Vista had exclusive authority over comprehensive planning, land development regulations, development orders, and building permitting within their municipal boundaries. While RCID had exclusive authority over those matters for lands in the RCID outside the municipal boundaries. Thus, as of the development agreement's effective date, RCID had no authority or jurisdiction to approve or regulate development-related activities on the property within the municipality's boundaries. So understand, RCID was a large district, and Bay Lake and Buena Vista were like little cities within them. So those little cities had their own powers. So RCID could not enact over Buena Vista and Bay Lake. Get where we're going here? Could not enact for those municipalities. They had to do it separately in their meetings, and they forgot to do it because Disney got sloppy. They rushed, they were panicking, and they got sloppy on this. A lot of people like to believe this myth of the invincible Disney legal. That's not what we have here. Thus, as of the development's effective date, RCID had no jurisdiction to approve of anything really within that boundary, whether it's a building permit, development plan, comprehensive plan. They couldn't approve anything. And the only signatories are RCID and Disney. Bay Lake and Buena Vista did not sign. RCID did not purport to sign the agreement on behalf of either municipality. They did not conduct public hearings on or approve the development agreement. Under the development agreement, the district assigns to Disney all development rights, including ones that should be held by Bay Lake and Buena Vista. In addition, under the development agreement, all proposed development, whether inside or outside of the municipality's boundaries, will be subject to RCID's land development. Because RCID had no authority or jurisdiction to regulate Bay Lake and Buena Vista, This was beyond their powers. It was ultra vires. Once again, ultra vires means beyond the powers. Therefore, null and void, both the development agreement and restrictive covenants. Are you seeing a pattern here? Are you seeing how Disney really did not pay attention? And let me bump up here. Disney really did not pay attention to the details. They were so afraid of the turnover that they're just like, let's just get it out. Let's just get it out. Let's delay. They're hoping they can stall. They're hoping they can negotiate. What they're hoping is they can drag out these lawsuits for 2 to 4 years and try to negotiate with maybe a DeSantis successor, right? Well, here's the problem. If this state court issue gets knocked out in a couple months, which it should, it's a very quick issue. It can get knocked out, although I know Disney will try to stall, of course. But if this gets knocked out quickly, the federal case goes poof. They got no standing. They got nothing over there. So this is a bad thing for Disney. Count 4, a violation of Article 7. So the development agreement requires the district to levy and collect ad valorem taxes. The development agreement constitutes a general obligation debt of the district for capital improvement projects. So whenever you issue general obligation debt, there's a big difference. This is something in the bond world. So I did a lot of bond issuances. I probably did, I want to say probably half a billion would probably be accurate in bond issuances. So not a full RCID's worth, not a billion, right? But a lot of money in bonds. I issue a lot of money. It might even be up to a billion. I really honestly never counted the amounts, but they were always very large, very large issuances, always in the millions, never anything less than that. Article 7 of the Florida Constitution states that if you have any bonds or indebtedness over 12 months, you have to, any general obligation debt, you need to approve that by a vote of the electors who are owners of the freeholds therein, not wholly exempt from taxation. You have to have a vote on any general obligation debt. That's basic Florida public finance law. If you actually study that part of bonds for the Florida bar, you would know that. Once again, these people forgot their little bond study from the Florida bar, and they don't practice in this area, so they just forgot. They rushed. Once again, they didn't know. RCID approved and adopted restrictive covenants as depending on the development agreement, so they're all valid. So once again, all invalid. And mind you guys, only one of these counts has to stick. If one of these counts sticks, everything is invalid. It's totally out. Are you seeing problems for Disney yet? And all of these I would concur with. There's not a single one of them that I'm like, no, that's wrong. Not yet, at least. Let's see. So prior to February 27th, Bay Lake and Buena Vista had exclusive authority over planning, regulation, and development orders. So these little cities had authority. They had real authority in their little area, right? They were puppets, but they were supposed to have that authority. RCID had exclusive matters over those lands within RCID outside the municipal boundaries. Think about it like this. For example, in Orange County, Florida, there's Orange County and there's Orlando. Within Orlando controls everything within Orlando. Within the county, Orange County controls. Let's say you're in, let me think of another city, right? Miami-Dade County, right? Miami-Dade County is not all one city, right? There's small cities. There's Kendall, Hialeah, Coral Gables, Miami Beach, right? Those all exist. Within Miami Beach, the county of Miami-Dade doesn't have the same powers. It has stronger powers in unincorporated Miami-Dade County. That is in areas of Miami-Dade County which are not within a city. That's how Florida government works. I know it's difficult, particularly for people who don't practice this area of law, but authority is a big thing, and not having that authority is fatal to any government action. You can never take an action unless you have the requisite authority, right? As Cartman would say, you got to respect the authority, but this is like real authority. So they were establishing guidelines for all three, for not just RCID, but for Bay Lake and Buena Vista. Now, they all conducted the first public hearing in 2018. However, there were major amendments, huge amendments. So 3.5 years later, RCID conducted its second public hearing on the resolution to adopt the Joint Comprehensive Plan. So they conducted it 3 years later to approve their comprehensive plan. However, unlike the first reading, RCID's proposed resolution did not attach any exhibits nor the text of the amendment. That's a fatal flaw. You have to attach that. RCID adopted the resolution and thereby put the purported amendments to the Joint Comprehensive Plan at that hearing. So you have to show what you're adopting. You can't just backdoor in changes and not show them to the public. This is a kind of like quintessential in Florida law. You can't just cram stuff through that the public doesn't have time to see. Most major things need 2 hearings in public, 2 public hearings in order to pass. I know it sounds crazy that like governments can't just do stuff, but that's how Florida government works. Often it takes 2-3 weeks to actually get something done because you've got to hear it twice. So Bay Lake, Buena Vista, they also held hearings on May 24th, 2022. However, they also lacked the proper exhibit. And what they actually adopted was materially different and followed a new purpose than what was heard at the first public hearing in November 2028. So there were major changes, right? Massive changes. And the public never got a chance to consider those at 2 hearings. That's the real problem here. That's a TLDR version of this, is that the public needed to hear this at 2 hearings, and they simply did not. So there were public hearings on December 14th, 2022, January 25th, January 11th, February 8th, January 11th, February 8th. But there was no exhibit or body of text that was showing the actual language of the amendment to the land development regulations. So this is government by ambush. This is hiding what they are doing and then just clipping it on later. You cannot do that. You cannot do that. Bay Lake and Lake Buena Vista had not adopted their ordinances concerning amendments to their land development regulations prior to RCID's first public hearing on the development agreement. Bay Lake and Buena Vista did not publish advertisements in the newspaper. This is a fatal flaw. No notice. If you have no notice, fatal flaw. Fails. No notice, just even one notice. Guys, one notice that you don't send out, it fails. It may not seem fair, but that's how the statute works. And what they'll say is just go ahead and do it again the right way, right? If you screw up, you just do it again the right way. And by the way, I've done that. Let me get a confession time here. Confession time. During my nearly 6-7 years practicing in special district law, in that field, in that specific field, I screwed up. I made mistakes. I was a new associate. I sometimes made a mistake, maybe in the legal description. Maybe I didn't clip on the right one, or there's an error, or there's something that needed to be added. And sometimes we had to run an ad again in the paper. It might cost a lot of money, right? It's a big fuck up on me. I got in trouble for that. You know, more than a slap on the wrist. And we'd have to do it when we'd have to approve things at a later meeting. We just have to bump it 2 weeks, 3 weeks, whatever, to get that done. But you had to do the notice right. I screwed up. I had to do it over and over again. But guess what? After screwing up 1 or 2 times, I never screwed up again because I understood how important notice was and how it's a fatal flaw in Florida government law. So there's this specific provision in Florida Statutes 166 that says no ordinance shall be revised or amended by reference to its title only. Boom. You've got to have the body. You've got to have the actual full text. Ordinances to revise or amend shall be set out in full. The revised or amended act or section or subsection of the paragraph of a section or subsection. So what they tried to do was they said, oh, we just put the title out there and that's enough. No. You cannot do that. Disney tried to bury this. It did not work for them. Section 166 of Florida statutes requires a particular type of newspaper ad to be published. Yeah, it's got to be in a very specific section, not just the back legal classifieds. It's actually got to be a larger spread. And it has to, once again, all other proposed ordinances of municipalities must be advertised for a public hearing pursuant to the minimum requirements of 166. So very specific requirements. RCID adopted its resolutions regarding the amendment to the joint comp plan, and therefore RCID was subject to the same statutory notice. So they had to follow those very, very specific requirements. And guess what? As we find out here, they failed to fully set out those amendments. They failed to hold a public hearing properly. They failed to start anew and have two advertised readings and public hearings because they did not include that full text. They did not have all of that information. So all of these, A, B, C, any one of these things, right? Any one of these reasons is fatal to Disney. But yet you've got more. You've got more. All you've got to do is one of these and everything is void. Do you see how at risk Disney is? Do you see how much they're risking here? With respect to the land development regulation amendments purportedly adopted in January by our CID, such ordinance is void and unenforceable because the official executed ordinance failed to set out in full the amendments. This is very true. You need everything in that resolution. I always made sure that all my resolutions were complete. RCID failed to hold at least one public hearing on the amendments to its land development regulations after 5 p.m. RCID had no authority to adopt land development regulations inconsistent with the joint comprehensive plan in effect at a time the ordinance was passed. And lastly, RCID had no authority to adopt regulations within Lake Buena Vista and Bay Lake, and such cities failed to properly adopt the regulations in tandem with RCID. So once again, all of these reasons, one of them alone is enough for them to fail. Once again, a lot of reasons for them to cancel and void these agreements. In addition, each of these is a separate violation of the mandatory requirements. So they're saying what I just told you here, which is each of these is a separate reason to violate them. They do not all need to be true. One of these things being true is enough to screw Disney and nuke their entire basis for standing. Do you see why Disney is in trouble here? Do you see yet? Each of these violations renders the amendments void. So because of that, they're in really big trouble. Because the development agreement violates the consistency mandate, it is void and unenforceable. Additionally, even if the 2002 amendments to the comp plan were effective, the development agreement converts the joint comp plan into a mandate and removes the district's statutory ability and in some cases its obligation to evaluate and amend the joint comprehensive plan. You cannot change the district's powers. This is a very important concept in Florida law. A special district only has those specific powers that are given to it. You cannot modify those without another act of the legislature. Disney's private restrictive covenants cannot reduce or increase the power of the district. The only thing that can do that is the legislature. This is a creature of the state. This is a creature of the legislature. Disney cannot modify its power by restrictive covenant. Just can't do it. Sorry. It's not how it works. So because of that, all of them are unenforceable and void. Lots of reasons there packed into count number 5. That's a really good one. That one was solid. Solid. Count 6, unlawful delegation of government authority to a private entity. This is what I've been saying the entire time, guys. This is me. This is what I have been telling you the entire time. The precedential effect here, that you cannot delegate governmental authority to a private entity. What is your boy been saying this entire time? This is the first time this complaint's come out, fresh off the presses. It's confirming every single thing I've been saying, not just for the first past months, but for a while. I've been preaching this to the choir. You cannot delegate this. This is settled Florida law. I'm glad they're bringing this up here. Florida law prohibits a local government from contracting away its discretionary legislative power. Yes, settled Florida law. The development agreement contracts away their discretionary legislative power in multiple ways. It provides that if there's any conflict between itself and the comp plan, they elevate a private contractual agreement above the legislative acts of RCID. That is not okay. You cannot do that. It gives Disney authority to set all building heights. Once again, the district is the only entity empowered to do that, not Disney. It also goes on to say they obligate the district to fund and construct facilities to accommodate Disney's future growth. That is also not okay. You cannot force a government to take actions like that. Not okay. Each of these delegations is unlawful. So each and every one of these delegations is an unlawful delegation, therefore unenforceable. Restrictive covenants are tied to the development agreement. And because of that, void, right? So void. Section 2.1 of the restrictive covenants restricts the district to using property solely for the uses existing on February 8th. Section 2.2 effectively enables Disney to censor the district, banning the district from speech on its own property about anything other than district. So literally censoring the district. So all those 1A advocates, all these free speech advocates, all of a sudden, yeah. Did you read the restrictive covenants and the development agreement? Clearly you didn't. Clearly you didn't see that Disney is really the one who wants to stifle the First Amendment. And we always knew that. Come on, we always knew that. Section 3 prohibits the district from altering its own property without Disney's review and consent. Its own property. Imagine that. Guys, imagine that a homeowners association tries to tell the fire department, you know what? You can't build that extra parking area for the ambulance. You can't do it. What you got to build is a jungle gym. That's ridiculous, right? That's preposterous. Well, that's what we have here. Disney is allowed to tell the district what they can and cannot do. Ridiculous. So because that's an unlawful delegation of governmental power, it's null and void. I 100% agree with this. And this alone, guys, this argument here alone in count number 6, this alone would be the most insane precedent in all of the United States for a government to be under control of a private entity. For this reason alone, these are going to get shot down because of the precedent this would have for HOA Karens all over America. Count 7, and obviously void against public policy. Now, I haven't got into this yet, but public policy always tends to be a weaker argument, but there are sometimes valid points to make under public policy. And mind you, it's count 7, so we're getting later in the counts, right? So you're going to want to put your stronger counts first, your weaker counts later. Void against public policy. Agreements that contravene the legislator's intent are void as against the public policy. So the Florida legislature established what governs the district. So the Florida legislature is the only body that can govern the district, not Disney. This law replaces the district's prior landowner board with an independent board. The law also maintains the district's authority to adopt planning, zoning, and other regulations. In short, HB 9B provides public oversight for the district and ensures that the same laws apply to the district as apply to the state of Florida. Although HB 9B was still under legislative consideration on February 8th, when the development agreement and restrictive covenants were approved, right? That's been enacted and constitutes a public policy against which any attempted enforcement of the development agreement will be judged. The development agreement contravenes HB 9B in multiple ways. So, for example, this is sort of a catch-22 situation. So the development agreements that kind of say, hey, look, you can't do anything you weren't already doing, but the new law, the new bill that brings in the new district instead of Reedy Creek, the successor district, it sets new rules. So what you're doing is you're saying under the old rules, you can't play by the new rules. You can't really do that. You can't really do that. It says, that in the development agreements, they seek to stop the district's authority to regulate the density of population. Also, under the development agreement, Disney may obligate the district to construct public facilities and even to purchase from Disney. So, forcing the district to purchase land from Disney that is needed for facilities. The development agreement restricts the district from reassessing the relative costs and benefit of such facilities. That is insane. So, they're saying that Disney is going to dictate the price at which they pay and sell and buy facilities. That is ridiculous. So they say the district, Disney in their federal complaint, they said, oh, yeah, the district still has all its powers. No, if you're telling them what to build and what to not build, they don't have all their powers. They would indeed need to come to Disney. They would be Disney's bitch. That's not how it works. Disney cannot maintain control by restrictive covenant. That's not going to work. This legislature enacted HB 9B to create a board that would exercise meaningful public authority over the district, including over land development. But the development agreement removes that authority by exempting a large swath of land from district regulation and transferring zoning authority over that land to a single private developer. Therefore, it contravenes HB 9B and is void against public policy. Once again, guys, I'm saying this again and again, but it's worth noting. Any one of these things, as I'm reading them, one of these things, we're at line 132. And mind you, the first 36 or so lines were facts, but any one of these lines is enough. Do you see the problem? So, once again, both the restrictive covenants and the development agreement, because they're kind of go together, they contravene law, contravene public policy, and they're void. We read this about section 3 and section 2.1, 2.2, 2.3, censoring the district, all those null and void. And then you got unconscionability. This is kind of more of a long shot, but saying a contract contrary to strong public policy against a particular practice is unconscionable and unenforceable. Always the weakest argument. Unconscionability is always the weakest argument. So you want to put it near last, which I believe it is here. Because the development agreement and restrictive covenants each violate public policies, they're unconscionable and therefore unenforceable. Independent of HB 9B, however, the development agreement is both procedurally and substantially unconscionable. So they're not just saying it in a one-off here. They're saying it is as a whole unconscionable. Indicators of procedural unconscionability include the evidence of self-dealing, and here we go, guys, the lack of independent counsel. This is massive. This is why I always told people, and my firm would tell them, other people would tell them, we cannot have company employees. If you're the developer, you're a real estate developer, we cannot have those company employees working on the council team, on the management team as administrators. They need to be separate. My firm was completely separate and independent, even when we represented developers. You have to have independent legal counsel. Under the prior manner of electing board members, where each district landowner was allowed one vote, Disney's ownership of all such land ensured its absolute control. Based on its information and belief, it transferred parcels of land to members of the board for minimal consideration in order to assure that all board members be district landowners. Based on the information and belief, Disney retained the right to demand return of this land. This pattern of self-dealing resulted in substantially one-sided provisions of the development agreement. Yes, it did. They also lacked independent counsel. Here you go. The district's general counsel, John McGowan, at the time also represented Disney in real estate and other matters. Also, oh, by the way, I think it was Ed Milgram as well. So both, John McGowan was the chief counsel for Disney, but also Ed Milgram was representing Disney as well on several other deals. So that's a big, big, big issue. And his communications with Disney's counsel related to the development agreement indicated a desire to maintain business with Disney. Huge conflict of interest, huge ethical issue. And listen, I don't say this lightly, but I think there should be ethical ramifications under the Florida bar for Ed Milgram. Just saying. Just saying here. Communications between the district's general counsel and Disney's counsel also indicate that Disney drafted the development agreement, but attempted to obscure this fact by naming the district general counsel as the drafter. So they tried to name, at first it was drafted by John McGowan, Disney's counsel, but they switched the name for Ed Milgram, who was the district's counsel. Mind you, when I say district's counsel, he was still representing Disney. He was still self-serving, self-dealing. So both these guys in potential hot water. These communications further show that Disney's counsel edited the text of the agenda item for RCID's January 25th, 2023 meeting. The evidence reflects a procedurally unconscionable attempt by Disney to arrogate authority to itself on the eve of HB 9B's enactment. Substantive unconscionability focuses on whether the terms of the contract are unreasonably favorable to other party. So the benefits are entirely one-sided. Disney gets exclusive use of the development rights. It delegates the powers to Disney. It allows Disney to obligate the district to construct facilities and allows Disney to obligate the district's ad valorem taxing authority in order to construct those development projects. The district receives nothing in return, no consideration, which is something we're going to get into in a second. The only theoretical benefit to the district in the text of the development agreement is that Disney obligates the district to construct private facilities. So the only thing the district gets is to spend money. It's that it's forced to do something. That's not really getting anything. That's like, okay, your gift is you get to mow my lawn. That's not a real gift. So Disney will not request payment for the land in excess of fair market value. Oh, Disney promises to pay, to pay fair market value. Okay, great. The purported benefit is illusory because the district has the power of eminent domain, meaning that it may take private property for public use and just compensation. Because payment of fair market value is exactly what you get when you do a taking. There's no real benefit. There's nothing benefiting the district. And these one-sided benefits are long-term. It lasts for 30 years, the maximum amount of time under the Florida Local Development Agreement Act, also the Marketable Title Act as well for the restrictive covenants that would come into play. This length of time extends for 20 years beyond the Joint Comprehensive Plan purportedly adopted in May 2022. In this context, the development agreement's duration exacerbates the unconscionability of its one-sided terms. It's trying to lock this in for 20 years. Because the development agreement is both procedurally and substantially unconscionable, it is void, unenforceable, or invalid. Because the restrictive covenants depend on the existence of the development agreement, they are void as unconscionable. The restrictive covenants are also the product of the same self-dealing and absence of independent counsel. So they were also drafted by Disney, and then they backlogged it to Ed Milgram to the district. And here we go, count 9, lack of consideration. All contracts require consideration. I like this. This is very clean. Now, I will say my critique is this is not a normal contract. This is a statutory contract. So I'll actually come at this drafter a little bit. I know this is your count number 9. So once again, you're getting your weaker arguments. But remember, statutory contracts only require what the statute requires. So it's not requiring unlimited. It's just requiring what the statute requires. Let's be very clear about that. But I will agree, general contractual principles do apply to an extent, right? You cannot have a contract with no consideration. That is true. Consideration must be something more than what a party was already legally obligated to do. That is also a fact under contract law. So the only thing they got was fair market value for the land, which was already something they could get with eminent domain. They didn't really get anything. They had no consideration. The district would have no consideration. Therefore, development agreements null and void, restricted covenants are null and void, and let's get here. The restricted covenants constitute a distinct agreement, yet they do not even purport to have their own consideration. So the restrictive covenants, they're buried as part of the development agreement, but there's no extra consideration for those either. Nothing really. They're just added on, clipped on. Mind you, I would make an argument, which they haven't made so far, that you need notice for recording restrictive covenants on all land within the district. I would say that's required. However, that's not something they threw in here. But I think that's because they're suing on behalf of the district. They're not suing on behalf of all property owners. Okay, I got that. But I'm just want to throw that out there as well. So the development agreement had not been executed and approved by the time the former board voted to approve the restrictive covenants. A non-existent agreement could not constitute consideration for the restrictive covenants because they lack consideration. The agreements are void, invalid, done, gone for. That's all 9 counts. So obviously the later counts 8 and 9, count 8 and 9, specifically the counts regarding consideration and the counts regarding here unconscionability. I think these are weaker. I think these are weaker. I'll be honest with you. These are weaker counts. However, only one thing needs to be true for them to knock everything out. And by the way, I think that the unconscionable argument is still a strong argument. I just think that the other arguments, particularly the notice requirement, that's hard and fast under Florida law. That's not something you play around with. I think that's going to knock them out 100%. So they're asking for them to null and void the development agreement, the restrictive covenants, to enjoin them from enforcing the development agreement, and to grant any other relief. So this is exactly what they need, signed by Alan Lawson, former Supreme Court of Florida judge, and Lawson Huck Gonzalez over there in Tallahassee. Now, here's the exhibits just to show you. These are the development agreements, which, by the way, you see Ed Milgram's name up here. This was substituted. This was originally this was John McGowan, the chief counsel for Disney, but for optics purposes, which we saw the emails when they said this, for optics, they switched it to Ed Milgram from John McGowan, Disney's counsel. So that being said, guys, that's what we have here. This is an absolute blowout. This is going to be insane. The fallout from this is going to be massive, and I'm going to be here covering it every single point of the way. This is the real battle. And today, I think the district, what they filed is a strong chance of knocking this out completely, defeating the federal claim, and actually recapturing authority for the state of Florida and the citizens of the state of Florida who just want Disney to play by the same rules as everybody else. Until next time, guys, peace.